In previous videos, I've documented how significant and excessive fees disproportionately affect participants in small and mid-sized businesses, because the large businesses, ironically the ones who get sued for excessive fees, are actually able to take advantage of economies of scale and pass on far lower fees to each participant. The reason they're getting sued, if the fees are still considered excessive by some attorneys in our courts, is because there's simply more participants and more money in it to make it worth it for the attorney to actually spend time. The sad thing is, the plans that are too small for the attorneys to waste their time on, those are the ones whose participants are getting creamed even more. Those are the ones who actually need more help. One particular example of an industry that's disproportionately affected is law firms. Law firms are especially affected because they have lots of money and they have lots of contributions amongst the employers and the employees, thus pushing up the account values. Because these fees are asset-based, they are continuing to increase without any additional services being provided. And as I've mentioned previously, because there's no bill being sent and because the employers don't pay these fees, and I say no bill being sent, meaning no bill to even reflect the fees that are paid by the participants, the employers, and some of those examples are law firms, have no idea what's going on. Yes, sometimes it's a friend of one of the partners and they deliberately decide not to look into it. But even if they did, they still don't have enough information to make informed decisions. So if you are an employee of a law firm, a partner of a law firm especially, or most importantly, if you are a managing partner of a law firm who oversees these retirement plans, please listen to what I'm saying. You are so much better off paying the fees at the employer level and demanding that all of the service providers send a bill. Of course, you're going to be more sensitive to the cost. Of course, you're going to start negotiating, and then you are more likely to seek out providers that are far more affordable. I've mentioned many times that Vanguard offers a fixed dollar fee pricing model. So no matter how much money a law firm has, they will never pay additional fees for having additional contributions or because of the growth of the market. There's also the ABA retirement funds program that's only available to law firms or those that service law firms. And what's particularly interesting about this program is they offer what's called a self-directed brokerage account. There's a small cost per person to those who set it up on an annual basis, but there's no record-keeping administration or custodial fees that are paid by the participants. That's all paid within the list of default funds that are available. But if you go outside of that, you don't pay any of those fees. It's all the remaining participants that are essentially subsidizing that plan for everybody else through what's known as revenue sharing, which is a kickback built into the cost of the funds to pay for record-keeping, administration, and custodial services. But back to why law firms have such a strong interest in paying the fees themselves and or minimizing the fees is because the partners have most of the money in the plan. The partners are the owners, and typically the owners have the largest balances. These fees are not passed on equally. I've said this before, and I want to reiterate that the fees paid by the participants are passed on in proportion to the account balances. So those who have the highest balances are paying the vast majority of these fees. Well, financial planning fees, as well as record-keeping, administration, and custodial fees, I believe, as of now, are not tax deductible at the individual level. But like any other business expense, if you pay at the employer level, you do get a tax deduction. And this is important to note, retirement accounts are either tax-free or tax-deferred. You want as much money growing inside of those accounts. And as a recruiting tool, you want to pay all the fees for the participants. If they appreciate it, then they are going to be much more likely to work for your firm, because simply passing on an extra 1% in fees, and I've documented this before, for a 35-year-old with a $25,000 balance will cost 28% of the balance over this participant's lifetime, and in dollar figures, about $67,000. So as a law firm, you can significantly differentiate yourself from every other small and mid-sized law firm by simply paying for the record-keeping, administration, custodial, and advisory fees at the employer level. But here's how the industry can be changed. Once law firms have actually gone through this process and they actually understand what's going on, how the retirement plan industry actually works, and what you can do to stop yourself from being taken advantage of, then they can disseminate this information to all of their clients. Attorneys are respected service professionals. They provide advice in different areas, and while it may not be directly related to a retirement plan, clients typically take their advice seriously. And this can be a legal matter because there are fiduciary liability issues for passing on excessive fees, not at the employer level. The government doesn't care what the employer is paying. The laws in place regarding excessive fees are there to protect participants. So these excessive fees only apply to fees that are passed on to the participants. Law firms are typically not parties to these retirement plans, so they're not part of the industry. The record keepers, the administrators, the custodians, the advisors, sure, they could start structuring their practice around the message I have, which is pay at the employer level and flat fees. But the entire industry is addicted to asset-based fees. They're addicted to hiding from their fees because once you send a bill, then you actually have to do work to justify what you're charging. And because advisors are charging, and record keepers too, amazingly enough, as well as administrators getting additional fees out of these accounts that are not part of their direct bill, they don't want to be confronted. They don't want to provide an accounting of their fees because then they're going to have to do a lot more work. They're not going to make as much money, and they're going to have to explain themselves why they're charging these fake management fees. Even Ted Benna, and I've said this before and I'll say it again, the inventor of the 401k, has been critical for the same reasons as I have of retirement plans. He has explained that these fund lineups all look the same, that advisors, record keepers too, are not doing an original piece of work, when they really should be getting back to a fee-for-service model like any other service professional, like accountants and attorneys. Attorneys have their own model. Sometimes it's on a contingency, but for the most part, attorneys charge a retainer fee, and they have to document how they spent their time. There's no reason why financial advisors, administrators, and record keepers should not be held just as accountable and provide an accounting for their time. So yes, law firms, mainly small and mid-sized law firms that are being disproportionately affected by these excessive fees. I've documented over 100 of them just throughout the Chicago area alone by going through the publicly available 5,500 forms. I have over 10 years worth of data. These attorneys can be catalysts to change the industry for the better.